memo means presumably applies with respect to the treatment of U.S. Citizens abroad. Now, in fact, I think that's the kind of consideration that should have been brought to bear in the analysis of the treaties themselves. If we conclude that this kind of conduct is consistent with the Torture Convention, then we're basically saying it's not torture if it is perpetrated against U.S. personnel. I don't know whether you need to use an executive order approach. I haven't really thought that through, but I think when you're dealing with an international law instrument which is based upon reciprocity, that should be a touchstone consideration in your analysis of your obligations and your rights.
It was very interesting as you looked at the decision-making process over and over again when the military lawyers got involved in the discussion, they were pushing this point. Why? Because they deeply understood what would be happening to military men and women abroad. So the military lawyers, not uniformly, not always, but quite often, really almost heroically, were pushing this point internally.
I'm just scanning the audience to see if there are any students. Okay. In the green hat? Is that Jamie? Okay.
Hi. So I'm curious, a lot of the focus on accountability has been on criminal accountability in terms of what we do to redress, and we're talking about the lawyers. And I'm wondering about the survivors of these torture techniques and whether there's any room to give them any sort of compensation or redress within our options.
Well, Jose, and people who should know have pronounced his name Padilla Padilla. He's convicted, and he survived the pleadings, right, on his deprivation of constitutional right lawsuit. So does anyone know why people who are tortured would be barred from proceeding as he's doing?
Well, the problem is that any kind of damage action of that sort involves very substantial immunity defenses. So you can bring the action, but it's very difficult to prevail under existing law. The Torture Convention actually has a requirement for redress for victims, although I don't think that's really been operationalized at all. And of course, I mean, an example, I don't think we've talked about it explicitly, a lot of people I'm sure are aware of it, like the South African experience, with the Truth and Reconciliation Commission, the decision was made, basically there were not going to be prosecutions in general, but the healing process was that as long as people told the truth, both victims and perpetrators, that there wouldn't be prosecutions, but there would be a very expanded record of what had happened that would validate the situation of the victims and help to assure that practices like that couldn't be followed in the future. Now, of course, South Africa is a different situation than here, but that was the compromise that was worked out there. And so we know much more about how people are tortured by the government from the South African Truth and Reconciliation Commission than has probably ever been put on the record any other way.
Okay. Gwen?
Yeah, just speaking to the point that was made that we have to show that this was aberrational, that the U.S. doesn't condone torture, or there's not a long-standing practice of torture. And I would just like to point out evidence that has been presented that the U.S. is actually, or that the CIA specifically has actually honed these techniques, these sorts of techniques since the Cold War. And this is work by Alfred McCoy. And I was just kind of wondering, just in that context, I mean, do you think that's something that should be brought out more in the left's discussion of this? Or
louder, please.
Is that...
Louder.
I'm almost...
I can
done,
repeat the
but,
question. No, please, you go mic. Yeah.
Okay. So this is just about the research on CIA interrogation practices that have been honed since the Cold War that basically employ torture. And whether or not we should be using that to our advantage during these arguments, during, leading these arguments, or is that going to be used, is that something we should
So I'll just tell you from the experience of having been in the executive branch, one of the things I always find amazing, both internationally and within the United States, is the incredible faith in the capacity and power of the CIA, which I can tell you, having worked closely with them, that does not track my own experience at all. And one of the things that I found interesting, just from the media reports, is that in fact, right? When the CIA wanted to do these things, they didn't know how, right? They had to go, where did they go? They went to the US military to look at the techniques that were being employed in search, evasion, resistance, and escape in SEER school, right? Which is standard training that's offered for US military personnel who are at enhanced risk of being caught behind enemy lines, right? And so I just don't know if it's true. If it's true, by all means, we should talk about it.
I mean, I think that there is McCoy's book is really good. I think it's called A Question of Torture. And he basically advances the idea that the CIA had been fascinated from really right after the Korean War, seeing how American service personnel who'd been held by the Koreans had renounced America and made all kinds of accusations. And they said, well, how did they do that? And they basically debriefed people to find out. And so they got fascinated by this idea of touchless torture, which is sometimes, I think, inaccurately referred to as torture light. That is that, and you can see that in John Yu's memo, I think, basically, as long as you're not cutting or burning or electrocuting or mutilating somebody, and all you're doing is depriving them of sleep or stopping their breathing, then it's not really torture. And McCoy's thesis, and there's a lot to support it, I think, that done aggressively, sleep deprivation and the other techniques are fully as capable of torturing somebody as much as cutting and burning them. But there's some hazy acceptability to the non-touch techniques. Whereas if we were reading about people getting, actually drilled with the electric drill rather than merely threatened with the electric drill, then we wouldn't be saying, oh, was that torture? But the results, McCoy says, and I think there's a lot of support, are basically the same if you really want to push those techniques.
Okay, I'm just going to take two more since we're nearing end. Sushil?
I wanted to return to the issue of academic freedom as a shield to Professor Yu and panel about what you think about a university investigation into professional or ethical misconduct of Yu's role as a government lawyer on leave from the university. And whether you think academic freedom should be used as a shield there.
So I may have a really unpopular opinion in the room on this, but I actually am a sort of huge proponent of academic freedom and other writings that I do. I think it's actually really important for society. I think the university does play a really, really important role in U.S. society in providing a space for people who aren't really beholden to any economic interest to say, even really outrageous things. So the reason that I am afraid of a UC investigation with respect to academic freedom is that it sounds a lot like a threat, right? And so I think that it all depends on context, right? And I know nothing about this, I'm just visiting here, but has the UC system investigated people before? Does it always end in the person being fired, right? Or
Is it crimes they have?
I'm sorry?
If they've committed crimes they have and they are obligated to do so.
Right, so I guess...
We're not talking about opinions. We're not talking about opinions. Academic freedom, it's not about opinions.
I understand that, but I think the problem is that it's actually not clear if a crime was committed by Professor Yu or not, at least not to me. I think I abhor what was done, right? I really criticize, I think it was horrible, but to me it's not clear that he committed a crime, and I think that's part of why you see Dean Edley and others being afraid of sort of jumping to an investigation for that reason.
I thought Dean Edley's statement left open the door if there is a criminal prosecution or a serious discipline by another tribunal. I thought he left that open. And so what I primarily question in addition to these thoughts is the competence. They don't do this for a living. So state bars are supposed to know the piece I talked about. Criminal prosecutors, as Professor Sims said, are supposed to know their piece. I just don't know that an academic senate would really know how to prosecute a crime or an ethics violation. So if Dean Edley really was saying, if the hammer comes down authoritatively by another body, then we can look into it, I don't think that's unreasonable.
And of course, the University of California doesn't have the power of subpoena, and so, even the Justice Department has had a terrible time finding out what happened, And in many of these investigations, even the Justice Department lawyers couldn't get clearances to see the material that